Hello everybody. Today we're going to be starting a new section in our notebooks. So the first thing I need you to do is open up your notebooks to the first available page and title it The Bill of Rights. As you guys go through these notes today, please keep in mind to pause the presentation anytime anyone needs a little more time in getting their stuff taken care of. All right, so we're moving right into it. Changing the Constitution. We've discussed this already. The amendment process is changing the Constitution in order for the Constitution to continue to be a living document. We've discussed the amendment process, so you don't have to write this down. It's just a review. In order for the Constitution to change with the evolution of people, the founding fathers had to have a way to change it. However, the process couldn't be too easy, and they didn't want people changing it haphazardly. As James Madison was creating the Constitutional Bill of Rights, he had to think of how much freedom should he give the American people and how much freedom should he withhold. So these were just things that he had to worry about. And of course, remember that James Madison is the father of the Constitution and author of the Bill of Rights. All right, so just a quick review, don't have to write it. Who demanded a Bill of Rights be included in the Constitution? We've discussed that the Anti-Federalists feared the new Constitution would not respect the rights of individuals as well as the state's powers. So they feared that without a Bill of Rights, of course their fear was that the federal government would steamroll them like the British government had done prior to the American Revolution. So let's get into the Bill of Rights. So the First Amendment to the Bill of Rights is your religious and political freedom. This includes your freedoms of expression, how you express yourself religiously as well as verbally, written, and gathering together. So freedom of religion, self-explanatory. You have the right to any religion or no religion if you so choose, as long as your chosen religion does not infringe on other people's rights. You also have freedom of the press and speech, keeping in mind that freedom of the press and speech was about speaking out against the government, not the ability to say whatever you felt like saying because, ooh, I have freedom of speech. That's not what it was. The whole purpose of freedom of press and speech was so that you could speak your mind with the written word as well as the verbal word against your country and not be in fear of being arrested, jailed, or harassed by the government. It was not meant for you to say whatever you feel like when you feel like. Another one, of course, is freedom of assembly, and this is our ability to gather in large groups. Keep in mind that prior to the American Revolution, Britain had started passing laws throughout the colonies, keeping them from assembling, from gathering in large groups. And when they were found in large groups, they were dispersed by the soldiers because of fear that the colonists would be plotting against the British. Of course, we were, but it was never out in the open. And then the last but not least is freedom of petition. Freedom of petition is a formal request made to the government asking them to either get rid of a law, to change a law, to alter it, or to create a law. And when you create a petition, you get signatures from your local voters, people who are affected by the laws, and those people sign the petition, and from there the government decides what's going to happen, whether they're going to repeal a law, hold a election where you vote in favor of a law or against a law, and so forth. So the First Amendment, in 45 words, it is 5 freedoms. This is directly from the Constitution. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. A lot goes into 45 words. Are there limits to your First Amendment rights? Yes, there are. Yelling fire in a public theater is not legal. Just the ramifications of doing that. If you're to yell it, think about that for just a moment. You randomly yell fire in a very packed theater. What are people going to do? Now, you should be thinking in your head, people are going to panic, they're going to freak out, and they're going to start running for the door. Well, in the melee, in all of that chaos, people are going to get hurt. They'll get trampled, they'll get pushed, they'll get shoved, they'll get just mistreated because people are going to be panicking. Bullying, teasing in a hateful way, racial comments, and sexual comments are also not protected by the First Amendment, and are considered harassment and can be prosecuted by an attorney in a court of law. So, not all First Amendment, let me rephrase that, not all speech and expression is protected under the First Amendment. Keep in mind to pause this at any point in time that you need to in order to get any of the information down. Freedom of assembly, this is just to show you an example of people who were protesting a law that was being passed, and they are standing peaceably. No one is rioting, no one is hurting anybody else, there's no violence, and that is what the First Amendment protects. Moving into the Second Amendment, right to bear arms. We've talked about this already. Any citizen has the right to own a firearm, keeping in mind, of course, that the right to own a firearm doesn't mean that just anybody can own one and that there are no rules. It simply means that the government has to protect your right to own a firearm and to be able to protect yourself. However, while it says this in the Constitution, it does not say how or who or when people can own a firearm. So the states take it upon themselves to make rules regarding the Second Amendment. For example, in the state of Texas, in order to own a rifle, one of the smallest ones, you must be 12 years old. You must have a license, and your parents must buy it for you. And of course, it can only be used for hunting. As you get older, the rifles get progressively larger, meaning that they have more firepower to them. And of course, things like handguns and certain knives, you're not allowed to own in the state of Texas. And in other cases, you're allowed to own them, but you must be 21 years of age. So, in the state of Texas, this could never happen because clearly this is not part of your right to bear arms, because this is definitely not an okay thing in the state of Texas. As I said, you have to be 21 to own it. You're not going to be a child walking around with a gun. So while the Second Amendment does protect your right to bear arms, it does not mean that anybody and everybody can have a firearm. The right to bear arms. James Madison wrote in the Federalist Papers, Americans have the right and advantage of being armed, unlike the citizens of the countries whose governments are afraid to trust the people with arms. Be reminded that Lexington and Concord was started because the British were going into Concord to remove the guns and the weapons that the colonists had collected. And the federal government and James Madison, the other founding fathers, when creating it, made sure that they were protecting people's rights to bear arms, that no one was going to take this away and the government couldn't force them. The Third Amendment, no quartering of soldiers. No soldiers can be quartered in any house without the consent of the owner during times of peace. And for those of you who are quick, you've already figured out why. The Quartering Act that the British passed prior to the American Revolution led to the Third Amendment. Again, founding fathers and people of the anti-federalist groups such as Patrick Henry and George Mason didn't want the federal government to be able to quarter soldiers in our homes. They wanted this never to happen again. It was a financial strain on the cities, or the colonies rather, and because of that, we put it into our Constitution so that it would never happen again. Great political cartoon showing this. The British soldier in the colonial home, and obviously the colonists are not happy about it. Never again will this take place. The Fourth Amendment. This is rules for search and seizure. This goes back to the writ of assistance. If you remember the Townshend Acts that we studied again prior to the American Revolution, the writ of assistance, allowed the British to get into homes and search for smuggled goods. They didn't need any probable cause. They could just decide on a whim that your house was going to be the one that was searched that day. So the founding fathers, again, made this a part of our individual rights within the Bill of Rights so that the federal government or any law enforcement, whether they be federal government, police officers, it doesn't matter, in order to come into our homes or search our personal belongings, they must have probable cause. Now, I'm going to clarify this. Probable cause means that they have a legitimate reason for searching your stuff. Now, in some cases, that means they get a warrant from a judge because they follow procedures and it's not pressing at the moment. But another type of probable cause are those probable cause that are pressing. For example, if a domestic disturbance has been called into the police and the police are told a weapon has gone off, that shots were fired in the home. When the police officers arrive, they have probable cause to go into that home. It is not a matter of they have to wait for a judge to get a warrant. That means that somebody is in imminent danger and they have the right to search that house. Another example of probable cause, you are pulled over for speeding on the highway, and when the police officer pulls you over, you are slurring your words, or a certain kind of smoke comes out of your car. The police officer smells it and it's not cigarette smoke. He has probable cause to search your vehicle at this point because there is suspicious behavior. That is probable cause. So it's not always about a warrant for those of you who are very much into TV and movies. Now, the Fourth Amendment doesn't apply all the time. For example, if you are an inmate in a prison, you are not protected from unreasonable search and seizures because you are already in prison. So you can expect very few protections when it comes to your privacy. Another example would be if you are in an airport. Those who go through airport security, it's different because of the danger that can happen, or rather the danger it poses for others in the sky. If you are to have a bomb or some sort of weapon, the airports do not have to have probable cause. They can search anybody that they want. They can search randomly, which they do, and they don't need a warrant for this. And as you saw in the previous picture, it goes back to the writ of assistance and police officers not just being able to search your home for any reason just because they don't like the way you look. All right, moving into the Fifth Amendment. This one is definitely more complex, and it's going to take us a couple of minutes to go through this. The Fifth Amendment is your protections when it comes to criminal charges. Anyone accused of a crime, first and foremost, has the right to a fair trial. And that individual cannot be tried twice for the same crime. Now, in a couple of my classes, we alluded to that particular part of the Fifth Amendment, and we'll talk about it a little more in depth here. First and foremost, the Fifth Amendment is the one that gives you the fair trial. So if you are accused of a crime, the police have to tell you what you're being charged with, and they have to have clear evidence that you've done something. Now, that doesn't mean they have to have physical evidence. It simply means that they have a very strong suspicion and circumstantial evidence to prove that you are guilty of a crime. And circumstantial means that they have an eyewitness who says they saw you, or they have there are reasons behind it. And we'll go in depth in that next week when I come back. The Fifth Amendment also, however, includes your right to not be a witness against yourself in a court of law. And what that means is if you are on trial for a crime and your attorney says it's not a good idea if you go on the stand because people won't be sympathetic, well, then you don't have to get on the stand. You don't have to testify for yourself because it may be detrimental to your case. Moving into the Miranda rights. part of the Fifth Amendment. We alluded to this in some other classes yesterday as well. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be provided for you. All of these statements fall under the Fifth Amendment so that you are protected and you do not have to worry about being arrested and not knowing your rights. We'll move into the next one.